Thank you very much. Thank you, Carolyn. I don't know what she was showing you up there. I mean, she'd come in, I'd say, Carolyn, didn't you know, a man walked into a library, he said, can I have a ham and egg sandwich? And the librarian said, this is a library. And he said, oh, I'm sorry, can I have a ham and egg sandwich? And she would say, we're supposed to decide the right to die case. You see, what are we doing? And anyway, she was really helpful and a great clerk, except I'm worried about what she was showing. But in any case, I wanted to talk a little bit about the book. I will for a while, and then you can ask questions. And why have I written this book? I mean, my goodness, I have asked myself that question. And the reason was, very simply, that we live in a pretty cynical period, I think. A whole lot of people suspicious of the government, and there's some justification, but if they become too suspicious and too cynical, they won't participate, and then where are we? We're in real trouble. And I think most people in public life would like to explain to other people whom they would like to see participate in government or in their communities, what is it we do? And it seemed to me the best contribution I could make there is try to explain to people, including law students, including lawyers, judges, but those who aren't lawyers or judges, what do we do? Now, it isn't all that easy to explain. I mean, people are busy, and they may not have time to listen. And we have to explain about an institution that's going to do a lot of things they don't like. And they're not popular, and they might even be wrong, this institution. I mean, I've certainly thought they're wrong on many occasions, but nonetheless, we have to accept it. Why? Why should I? And you don't want to be too dry. I mean, I did write a book about regulation. So, somehow that found its way into the hands of an LA Times reviewer. And I don't know how, but he said, in Alice in Wonderland, Alice comes out of the pool of tears with the Dormouse, and the Dormouse begins to read from Hume's History of England. Why are you reading that, says Alice. Because, says the Dormouse, we're wet, and this is the driest thing I know. And that was before Breyer wrote this book. So I understand the need to have an organizing question and a few examples. And what I've done is tried to have two questions in this book, which help explain my own feelings for the court and how I think I, anyway, will go about deciding difficult cases. And they are all difficult, really, all difficult. And the first question I want to ask is this, and it's a question I'm asked all the time, but I have to give you a little background. And it's not this question, but it stems from it. This question is, why did Hamilton and the others want the Supreme Court to have the power to strike down a law of Congress? I mean, we're not elected. We're unelected. They're the elected officials. And if you read Federalist 78, you'll see that Hamilton and the others did think that the court would have that power. Why? Well, he says, Hamilton, this is my imaginary reading of Federalist 78, but it's there. He sees what he's just helped write, and he thinks it's fabulous. And he's right. It is fabulous. He says, this is a beautiful document. But you know, if people don't follow it in the government, and the government just goes its own way, we might as well hand it up, just hang it in a museum. Let's put it in the National Gallery. Actually, they didn't have the National Gallery at that time. But nonetheless, you see the point. I mean, nobody will do it unless somebody says they have to do it. And who should that somebody be? Well, the president? The president has an awful lot of power already, and we don't want him to have the power to say everything he does is right, or he'll become a real tyrant. Well, what about Congress? At least they're elected. And he thinks to himself, this is Congress is a possibility, but this document gives rights and duties and gives document rights to people who are very unpopular. The least popular person in the United States has the same rights as the most popular person, and Congress, of course, are experts on popularity. They really know popularity. If they didn't know popularity, they wouldn't be where they were. And it's a little much to expect them, having passed the law, because it's popular, to turn around and say, now we'll do the unpopular thing of declaring it unconstitutional. So now who's left? And that, I think, is really it. Who else is left? There's a group of judges over here. Judges are sort of like bureaucrats. They're gray. Nobody knows their name. And this has something to do with law, this effort to strike down, see that there's a correspondence between the Constitution and the statute, and they're judges, and they don't have the power of the purse, and they don't have the power of the sword. Fabulous. They're not very powerful. Nobody knows who they are, probably won't abuse the privilege, so we'll give them the power. Now, it doesn't quite say that, but it comes close. And now this is the question I want to ask, which he doesn't answer. And that is, if these people are so gray and nobody's heard of them and they don't have the power of the purse and they don't have the power of the sword and they're going to decide things that are unpopular, well, why will people do what they say? Think of Hotspur. Think of Owen Glendower in Henry IV. He comes in, Owen Glendower, and he's a Welshman, and in Shakespeare all the Welshmen are mystics. And so Owen Glendower says, I can summon spirits from the vasty deep. And Hotspur, the practical Englishman, replies, well, so can I. So can any man. But will they come when you do call for them? Yes, that's the question. And that's a pretty big question. And I get asked that question a lot by judges from Africa, Asia, Latin America, and other places. Will people follow what the court says? And for a long time, it was pretty unclear. I mean, read Marbury versus Madison as you all have, but read it from the practical problem facing Marshall. Jefferson is sitting there just waiting for him to say, do it, so Jefferson can say, I won't. And Marshall knows it. And he gets around that one like Houdini by saying, okay, I'll say we have the power to declare a law of unconstitutional, but Jefferson, you win. What are you going to say about that one? You say, that's rather brilliant. But he had something to worry about. Indeed. I think only, and I put this in here because I think it's such a good case, the Cherokee Indians. I mean, in the 1830s, the Cherokees owned land in northern Georgia, and it was clear. I mean, it was in several treaties, absolutely theirs, and they had given up a hunting, fishing life, for better or for worse. They were farmers like their neighbors, and they had a constitution. They were led by their great chief Ross, and indistinguishable. But unfortunately for them, they found gold. Now, their Georgian neighbors thought, they're just Indians. Why should they have the land? We'll take it. And they went in and took it. And they, being civilized people, did what any group of civilized people would do. The Cherokees hired a lawyer. Now, he was a great lawyer, one of the greatest of his day, Willard Wirtz. He was Attorney General, great lawyer. And he represented and said, we're going to win. And after a lot of travail, they finally got their case to the court, and the court had to decide it. Worcester versus Georgia, they decided it. And in that case, they said, this land belongs to the Indians. That wasn't that hard. But that's the case that many of you will have heard of, because it is the case about which President Andrew Jackson supposedly said, John Marshall has made his decision, now let him enforce it. And Jackson sent troops to northern Georgia, but they did not go there to give the land to the Indians. They went there to evict the Indians, which they did. And the Indians traveled along a trail of tears, so-called, because so many died along the way to Oklahoma, where their descendants live to this day. So it was not a happy experience. And the fear of those who thought that the courts would not be followed seemed to be justified, at least in that kind of case. And it was a long time before the court struck down another law as unconstitutional. And I want my friends from Latin America, and there was a woman who came in who was the Chief Justice of Ghana, and she's trying to bring democracy, basic human rights, a rule of law to Ghana. And she says, well, why do they do what you say? And I think she has a good question. I said, the answer isn't going to lie just in this document. The answer is going to lie in the history. And the history starts off not so well, not so well. But I said, let's spin the reel forward. We can do that now. We spin forward to a later time. And the case that I really like, I think, is a wonderful case. After Brown versus Board. Because in Brown versus Board, the court went around and looked, and you have to be blind not to see what was going on. I mean, large portions of the country, virtually the whole, what do you mean equal protection of the law? There was no equal protection of the law. There was segregation in the South, and black people were a lot worse off than white people, and everybody knew it, and you didn't have to be a genius to figure that one out, and it was contrary to that provision of the law, and the court simply said so. You are not giving people equal protection of the law when you are dividing these schools racially, and everyone applauded, and then what happened in 1955? Nothing. Nothing happened. Nothing. Virtually nothing, let me not exaggerate. 1956? No, virtually nothing. The court made its decision. Well, nothing seemed to be happening too much. And then in 1957, a judge in Little Rock, with the school board agreeing, a moderate school board, said we will next September begin to integrate Central High School. And he entered an order and saying that these 9 African-American children will go into this high school, all white, Central High, and these 9 children were very brave and selected by the NAACP there, and they won their case, and integration was due to begin. What happened? Well, some of us were alive, remember that. I mean, Governor Falbus, who had previously been a moderate, decided he wasn't quite so moderate as some had thought. And he, with the White Citizens Council, sort of conniving, they surrounded the school in that September. And the Little Rock 9 couldn't get in because he'd sent the militia, the state militia. He said, well, they may have 1,000 judges, but I have the state police. And they're going to keep those children out of the school. And that first day, in that first week of September, they were out of the school. One didn't get the word that she wasn't even supposed to try. That was Elizabeth Eckford. And there were journalists from all over the world there. And there were big mobs in front of the school. And a picture was taken of Elizabeth Eckford, who's walking up towards the school very dignified. Actually, she was going back, in fact, away from the school because they had turned her away. And behind her is a white woman, her face just enraged. And that picture was taken and sent around the world. And that was what people thought showed the United States of America at that moment. By the way, I say parenthetically, I read a very interesting book by David Margolin coming out about what happened in later life to that woman, Hazel Bryant, who was a 15-year-old student who was showing off, and Elizabeth Eckford. And it's a very interesting story, which I recommend. Because Hazel Bryant was later sorry, well, a little late, but nonetheless, she was sorry, and tough.